Okay, I think that's close enough to 9 o'clock. I will call the February 16th, 2022 Mineland Reclamation Board meeting to order. And the way I see it, those in attendance from our board are Lauren Duncan, Tim Mock, Patrick Ortiz, and Jill Nelson. Is that correct, Cammie? Hello? Can anybody hear me?
That's correct. No, I can hear you. Sorry, it takes me a second.
No, I thought you might want gone to sleep or something. Anyway, on the agenda, we need we've called it to order. We need the approval of the January 2022 minutes.
Motion to approve.
I could have a motion to do that.
Motion to
Pardon me,
approve.
was that a motion, Tim?
Yes, sir.
Second, Patrick.
It's been moved and seconded. All those in favor of approval of the January minutes signify by saying aye.
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 Those opposed, same sign. Hearing none, the minutes of January 2022 are approved. Moving along, we now have, if you look, item number 8, enforcement hearing with Joe Forster of Gilpin County is now, is it a continuance? That's a continuance. Is that?
I'm sorry, which one?
Item
I
number
think
8,
that got
is that
moved to the consent agenda.
a continuance? Is that
No, that's the consent agenda.
consent? Okay, we have no continuances or withdrawals that I know of.
Nope,
So we'll
that's
move
it.
along to the executive director's report first, Mr. Mock, and then Jenny Brannon.
Great. Thank you, Mr. Chair, members of the board. Good morning, Director Brandon. Tim Mock, Deputy Director for the Department of Natural Resources. A couple of updates this morning. First, with the indoor mask requirements for most local health departments around the state expiring, DNR is no longer requiring employees to wear masks except where local public health orders and other non-DNR entities require it. We are keeping the requirement to work from home unless staff has tasks in the office, the work site, remaining in place. We are expecting some additional guidance regarding this matter pretty soon. Boards and commissions will continue to meet remotely, but Director Gibbs is considering requests to meet in person where needed. We are expecting further guidance from the governor's office regarding this month. We suspect that if the COVID-19 rates continue to decline, that the directive to meet remotely will be lifted. Couple of other updates. DNR posted a position for a new HR director that closed February 2nd. We're reviewing those applications and conducting interviews and hope to have someone on board probably mid-March. The Geographic Naming Advisory Board, Governor Polis has concurred with the Naming Advisory Board's recommendation to rename Chinaman Gulch in Chaffee County to Yansing Gulch. The recommendation has been forwarded to the U.S. Board of Geographic Names. Colorado Water Conservation Board, they kicked off the Water 22 Public Awareness Campaign, organized by the Water Education in Colorado as the supporting sponsor. This year-round campaign will focus on various water accomplishments, including the 100th anniversary of the Colorado River Compact, the 50th anniversary of the Clean Water Act, and the release of the next Colorado Water Plan expected at the end of this year. The Colorado State Forest Service is developing a forest carbon accounting framework for Colorado in collaboration with the Natural Resource Ecology Laboratory at Colorado State University, with modeling support from CAL FIRE and the U.S. Forest Service. This framework includes an ecosystem component and a wood product component to inform fuels mitigation and post-fire restoration projects and identify priority project areas, including where the largest benefits can be achieved from wood biomass utilization. And then finally, regarding wolf reintroduction and management, you may have read last week that CPW placed a GPS collar on a female wolf pup in North Park, Colorado. The colored pup will be identified as 2202. The first two numbers indicate the year the animal was captured. The second set of numbers inform biologists of the wolf's gender. Males will have odd numbers, females will have even, in the order in which it was collared. The pup is one of 6 produced by female wolf F1084 and male wolf 2101 in 2021, meaning the new collared pup is one of the 8 wolves in the North Park area. The female 1084 is known to have migrated to Colorado from the Snake River Pack in Wyoming from a previously fitted collar that had expired. And then gray wolves, as of at the end of last week, are now under Endangered Species Act management. Recent court ruling restored protections to gray wolves under the ESA in Colorado. The ruling also returned management authority of wolves in Colorado to the U.S. Fish and Wildlife Service. CPW has been in communication with the U.S. Fish and Wildlife Service regarding management from the outset of this restoration management planning effort. More immediately, we are reviewing the court's decision and are in contact with the U.S. Fish and Wildlife Service to understand implications of this decision on Colorado's gray wolf reintroduction process. And that concludes the EDO's update. Thank you.
Tim, does that change the wolf plan in Colorado, that ruling by the U.S. Fish and Wildlife Service? Does that have any effect?
We're working on understanding what that really means. I mean, what it does mean is that the feds will have a more involved role, and they will have to sign off on our wolf management and reintroduction plan. We'll also have to file some additional paperwork with them. We're not certain right now. We're still operating that the existing timeline by having wolves on the ground no later than December 2023 is still in effect, and we'll meet those deadlines.
Okay. Okay. Thank you. Any other questions for Mr. Muck? Comments? With that, we're anxiously awaiting a report from Ms. Brennan.
I know you are. Good morning, everybody. Ginny Brennan, Division Director. I'll be very brief. The infrastructure funds, it looks like, have come through. I mean, we have to technically apply for them, but
Yeah.
that's an administrative task. And so we are looking at 10 million coming into the next fiscal year, and we're hoping 10 million each year for 14 years after that. Sea change for the IMP program in terms of coal mine fires, and also closures at abandoned coal mine sites. And speaking of coal mine fires, the Marshall wildfire set off some waste piles from the old Marshall coal mine fire. And so we've got contractors' boots on the ground this week, making sure that those smoldering waste piles are extinguished. And the delay actually was only because we had to get landowner approval, and there's 6 different parcels, both public and private, that we had to get approval to get on. So anyway, so we're doing that, and that's about it. It's not, I mean, it's a big deal. We'll be FTEing up in that program, and it really is a big deal, but that's all I have for the report.
So
Questions
as
or
I
comments?
read that, the $10 million can only be used regarding or in relationship to coal mines. Is that right?
That's correct. That's correct. Only coal mines. And a lot of it
Okay.
has to do with community revitalization, with laid off coal workers as coal continues to go down because the power plants are taking coal less and less. But it also stems from the fact that, you know, coal's the only one that's paid a fee since the inception of our laws. Hard rock's never paid a fee, which is why we're always hamstrung when it comes to these hard rock sites in terms of doing remediation, the reclamation, because we don't have a dedicated source of funding. There's bits and pieces here and there that we cobble together, but there's no dedicated source. So that's part of it too. But it'll be like A lot of it will be along the Grand Hogback, kind of going from Glenwood up to Craig. And a lot of that, you get to west Colorado, that's really where we've got coal impacted communities. And so we will definitely be focused on infusing those dollars into those communities. And where we can, hiring local contractors who will hire ostensibly local workers, and coal mine workers would be perfect for those jobs. So. Anything else?
Any other questions or comments? Okay, thank you.
Yep.
Item number 4, we now have on the consent agenda what was item number 8, which was an enforcement hearing. Joe Forster of Gilpin County. Is there a motion to consent agenda?
So this is Lauren Duncan. If you
You
can
guys are
hear me
quiet this
okay.
morning. You need to have a Bloody Mary or something to get started.
Uh,
Yeah.
Second.
Actually, before we approve this, can anyone hear me? Yeah, oh, that's nice.
Yeah.
Great.
Yes.
Thanks for the little bopping
I
head.
can.
Okay, wonderful. I was just
Yeah.
wondering how that kind of conversation went and what the next steps are here for that particular site. Seems like there's an
Somebody-
issue. We recognize that there was an issue, and that's all I know.
Yep. If I may, good morning, Michael Cunningham, representing the division. This item
Right.
was intended to go onto the consent agenda initially. So that is an error on my part for noticing that as an enforcement hearing. But we do have included in the board packet a copy of that signed consent agreement. So I can tell you that Mr. Forster, who represents Jack D. Tab, has been cooperative with the division. He ceased all activity out there at the mine and has committed to obtaining a reclamation permit for this project. I know that he is currently working on that and believe he's just got a few remaining items to put together. So I believe we'll see that application from him in the near future here.
Great. Thank you so much for the clarification. Well, then I move forward my motion to approve the consent agenda.
Second.
Q, is there a second?
Second.
Jill
Approve
seconded,
the
John.
consent agenda, signify by saying aye.
Hi.
Aye.
Right. All those in favor, is all those opposed, same sign? Hearing, item number 5 on your agenda is an enforcement hearing with Kevin Ames, Southport in Rio Grande County. So I guess staff, go ahead on item number 5.
Yes, sir, Mr. Singletary. Do we need to swear in prior to the presentation?
Yes. Sure. If there are there several people, some people that are going to testify?
No, sir, just
Well,
myself.
it's kind of hard. I mean, well, do you swear to tell the truth?
I do, yes, sir.
Okay, go ahead.
All right, good morning, ladies and gentlemen of the board. I am Lucas West, the Environmental Protection Specialist out of the Grand Junction Field Office, presenting this matter before you today. This one is short and sweet, so there is no presentation. However, there was a presentation form included in the board packet. This hearing is for the Hannah Pit number 1, permit number M2004-045. It's permitted as a 110C at 9.89 acres, but actually only 3.6 acres are disturbed. It was a surface sand and gravel operation like in Rio Grande County, just outside of South Fork. The last inspection was yesterday, and the site conditions remain unchanged from previous inspections. The nature of today's hearing is for consideration of the final forfeiture of the final financial warranty. Little bit of quick chronology on this site. Back in September, the board issued an order revoking the permit and finding the financial warranty subject to forfeiture. In January, the division noticed the financial warrantors in accordance with the board's order to let them know we were set up for final revocation. And to date, there's been no contact on the operator's behalf. So we'll move right into the statutes and statutes violated and description. The first two relate to the annual fee report and map requirements. And the third is CRS 3432.5 118 parent 2, which describes that when the board believes there's reason, or when the board has reason to believe that a financial warranty is subject to forfeiture, it shall so notify the operator and all financial warrantors, which we have done. The board shall hold the hearing not less than 30 days after the party's receipt of such notice, which this hearing does fall within that time frame. Small history of violations of the site. This site started out with a violation for operating without a permit. And then in 2014, they had another violation for failure to submit their annual fee and report. And then back in September of 2021 is what started this whole chain of events with another failure to submit annual fee report and map. So moving right into staff recommendations, staff recommends that the board affirms that the permit number M2004-045 is revoked and the financial warranty is subject to forfeiture. Number two is issue a written findings of fact and conclusions of law to support its decision and issue an order that the $12,000 cash bond is to be forfeited and direct the affected financial warrantors to immediately deliver to the board all amounts warranted by the applicable financial warranties pursuant to CRS 3432.5 118 parent 3 parent B. We also have order the operator cease and desist all mining activities at the site. I did forget to touch on that the current bond held for the site is $12,000. And as of the inspection yesterday, the division believes that that is adequate to conduct reclamation of the site. And at this time, are there any questions for staff from the board?
Any questions? Well, this seems pretty clear. Would somebody entertain a motion to approve the staff recommendations?
Yeah, this is Lauren Duncan. I can do that for us. For permit number M-2004-045, I move that we affirm the staff recommendations to affirm that permit number M-2004-045 is revoked and that the final financial warranty is subject to forfeiture, to issue a written findings of fact and conclusions of law to support the decision, and issue an order that the $12,000 cash bond is to be forfeited and directing affected financial warrantors, to immediately deliver to the board all amounts warranted by applicable financial warranties pursuant to CRS 34-32.5-118 parent 3 parent B. And finally, order that the operator cease and desist all mining activities at the site.
Second.
Okay, so moved and seconded. Who seconded?
Patrick.
Who seconded? Okay, all right. Been moved and seconded. Any discussion? If not, all those in favor of the motion, please signify by saying aye.
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 Thank you. All those opposed signify same sign. Any opposed? Hearing none, the motion passes. Thank you very much, Lauren.
Thank you.
Okay, we're moving on to item number 6. U.S. Forest Service litigation. The staff. Who is that? Amy?
All right.
So good morning, members of the board. I'm just going to do a quick intro because our operator is on the phone. So what this matter is that the operator is going to give a update on their litigation progress that has been made with the Forest Service regarding resolving the legal right of access issues. Currently, DRMS enforcement procedures relating to the possible violation for failing to maintain legal right of entry has been stayed. Or continued, should I say, and we have a cease and desist order currently in place until the enforcement matter can actually be heard before the board. Oh, and do we need to get sworn in? Sorry. Mr. Singletary, do we need
That's what I was going to ask you. Didn't want
Yes,
to. Well, all those intending to testify, please.
Aye.
Those intending to testify, please identify yourself and swear to tell the truth, please.
Amy Yeldell.
Travis Marshall, DRMS.
The operator, and you both swear to tell the truth?
Yes.
Yes.
I think we need Robert to unmute on
Mr.
the
Condon.
phone. Robert, can you unmute yourself on the phone?
Yeah, I gotta call you back.
I didn't catch that. Oh, there you go.
Hello, can you hear me?
Yes.
Yes, please identify
Yes,
yourself.
Robert Congdon, I swear to tell the truth.
And you're, okay, and tell us who you represent.
Mystic Eagle Quarry.
Okay. All right, Amy, then go ahead.
That's all I had is basically just that we are continuing enforcement procedures of this matter to let the Forest Service permitting kind of litigation side all work out, and Mr. Congdon's going to give us an update on where they're at in that process.
Okay,
Now?
Mr. Cogren, go ahead.
Yeah, you gotta excuse me, I'm in bad range. I'm breaking up a little bit when you talk, but the administrative process is working its way through the system rather slowly, but it is moving forward. As you're well aware, I believe from the board packet, that Snowmass has filed a new lawsuit, the 6-1 since 2001. And we're also filing an answer on that. So we expect to have that resolved in the future.
And that's about all you have to tell us?
Yeah, that's what I know. As I said, it is working forward. But there is dealing with multiple entities within the Forest Service. It's taken its while to filter through to everybody.
Okay.
This is Lauren Duncan. Quick question for you. In our board packet.
Any questions, Mr.?
Yeah, this is Lauren Duncan.
Yeah, go ahead.
I had a question. Awesome, thank you. I saw in our board packet a response from the Forest Service with a couple of follow-up items requested from the operator there. Mr. Cogdon, have you had a chance to reply to some of those? Is that kind of the process that you're referring to that's moving forward?
Yes, the responses have been submitted to them.
Okay, great. And then in the board packet, maybe this is a question for Ms. Yandel as well. There were a couple of additional pieces of information, not only the Forest Service response, but a question about someone potentially on the site, in a cabin on site. And that sounded maybe like a Forest Service specific issue. And then also a question over BLM payments from another entity claiming ownership to these claims. And it's a lot of information. A lot of it, some of it, personal family kind of things, but I don't know if we need to participate on any of those items, if you wanted us to comment, or if that's really outside the scope of today and we should just focus on the forward progress being made with the Forest Service.
Yeah, I don't know if Robert wants to chime in first, and then I can kind of follow up with a response for the divisions piece of it.
Yeah, I'm unaware of the other claim you're talking about, that the payments to the BLM. If you're talking about Snowmass Mining, they have lost their rights, but they did file a new claim in 2020. And the rights that they had with the old claims are gone, including a judge's decision does not follow a forfeited claim. They have filed new ones with a location date of 2020, October, I believe. And there's a 25-foot overlap onto our claims. It is the disputed property.
Okay, that's why this is relevant. Okay, thanks.
Yeah, and so
Yeah, I don't.
from, oh, sorry. So
No, I don't mean to add extra frustration. Just curious.
You can't add any more.
From the division standpoint, right now, the legal right of entry is directly tied to the operators having a active plan of operations. In talks with the U.S. Forest Service, the litigation side regarding claimant rights is not directly handled by the local Forest Service office. It's up to the BLM, who actually administers the minerals. And if they don't have a clear direction of who it is, then it goes to Pitkin County Court, which is where you're seeing those documents are being tied in. And so as of formal documentation, until the division gets notice from Pitkin County that they've either reversed the decision or it's been vacated or something, the division has to go off of Pitkin County's board, or their court order, which says currently Snowmass is the claim owners from that. And then kind of just to maybe elaborate a little bit more on procedurally where Snowmass is, or where Mr. Cognan's party is at with regards to permitting. I talked to Forest Service late last week, like Thursday. And the way it was explained to me is that the previous plan of operation, which this permit was reliant on for legal right of entry, Forest Service notified us that was null and void. Mr. Cogden appealed it, and that appeal has since been denied. So the old Forest Service plan of operation is dead, that we can't really rely on that. And so thus we're starting the new process. And that's where you can see the receipts where the Forest Service has acknowledged receipts of a new plan of operation, and then they've identified adequacy issues. We only have the first letter, but in talking with the Forest Service, there have been several reiterations for adequacy, just like our process in permitting, where they identify deficiencies for their act and rules, the operator responds back. And from what it sounds like, the operator is very close to ending that adequacy process, if you will. And at that point, then when they're done reviewing the plan and it's considered complete, it will get turned over to the local resource manager at the Forest Service office, I believe out of either Glenwood or Silt. And because this project, the EA, was done over 5 years ago, the local Forest Service has to review to make sure that the EA is still sufficient from a resources standpoint. So bearing that, nothing has been listed in the area, endangered species, anything crazy like that, that process shall be pretty quick. I was indicated that it's really probably like a week-long process, so it shouldn't take too much. And at that point, then the Forest Service will reach out to the division to conduct a site inspection. And that's when we'll start looking at the bond, which is the critical piece that the board wants to make sure that we have. It might be a little bit of a difference between what the Forest Service can bond for and what the division can bond for, just because our jurisdictional bubbles, aren't exactly the same. But we will work with the Forest Service to help make sure that the bond is calculated and is accurate for inflation and all that. And then at that point, once the operator posts whatever required bond amounts with the Forest Service, their plan of operation in theory should be active and good to go. And at that point, then the division can hear our legal right of entry matter. But yeah, it sounds like we can be anywhere from maybe a month out if wheels move quickly to, maybe 3-4 months is what from talking with Forest Service, it's all kind of just dependent on how fast they review and how fast the operator responds back with their stuff. But that's kind of our general take, is they are actively participating in the permitting process with the Forest Service. So we don't really have an issue there, and that it mostly just needs more time to work out.
Mr. Chair, if I may just quickly add my 2 sentences. This is Scott Schultz, counsel for the division. So essentially we have 2 issues. There's still this ongoing litigation and dispute on who is the proper mineral rights owner. That is going on in Pitkin County. That will take some time to go through the litigation process. Obviously intertwined with that is the issue that Ms. Yildell really spoke about, and that's the issue with the surface and the issue with the BLM and Forest Service, and that is still ongoing too. Right now, just to remind the board, we do have some new board members since this has been continued on, but this site is under a cease and desist order, so there is no issues. There should be no issues of anything going on at the site that the staff and the board is unaware of. So we just want to kind of remind you of that, and that's why I think we're more willing to really wait all this pending litigation out. So I think what I would suggest would maybe be a continuance for about 6 months till maybe July, as opposed to keep bringing it in front of you each month, and we're still kind of spinning our wheels. I think it just might be more efficient to kick it out to 6 months, see where we're at, kind of get another update, and then we can either go forward with the hearing then, or kick it out a little bit more to see where the pending litigation is. This is a very involved one, and we're happy to answer any questions. We just want to be careful because Mr. Condon is involved in active litigation, and this case is just notice for the right of entry issues and permitting issues. But with that, I'll stop, and thank you for your time.
Robert Condon here. Just one clarification on the Pitkin County judge making the decision. We filed
Any other
motion
question?
to move this to federal court. We're waiting to hear if it's going to be accepted or not.
Understood, Mr. Condon. Thank you. Right. This is like I said, it's just a complicated litigation matter that will take some time to be resolved.
Okay, thank you
Any other
everyone for
questions?
that.
Comments?
No other questions or comments. This is Lauren. I just wanted to say thank you for the clarification, everyone. Sounds like we don't need to make a ruling today, but it would be potentially helpful for everyone involved to make a motion to continue this conversation until July of 2022. It sounds like staff's on board with that, but Mr. Cogden, how do you feel about that?
Yes, that should be hopefully adequate.
Okay. All right. Thank you. I guess I would go ahead and make that motion that we continue this conversation.
Okay, let me ask Lauren
sorry,
real quick. Staff, is that what you?
Yeah, we're good with that.
Sorry, Lauren, I just want to make sure that's what the staff's looking for from us.
Yeah, thank you for the clarification.
I guess. Yeah, go ahead, Lauren, make the motion. Nobody.
Okay. I heard a yes from Ms. Yandel, and I saw
Lauren,
some
go ahead
head
and make the
nodding.
motion, please.
Yes, sir. I'm working on it. So for file number M-1999-042,
Thank you.
I move that we continue the conversation until July of 2022.
Second.
Been moved and seconded. Is that correct?
Yes.
Yes, it's been moved and seconded. All those in favor signify by saying aye.
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 All those opposed, same sign. Hearing none, motion passes. Thank you, Lauren.
Thank you.
All right,
Okay,
thanks for your time.
Item number 7 on the agenda is Stefan Mosevic. You bet. Stefan, is this right? Stefan Mosovic from Albert County, item number 7. To comply.
Yes, that is correct. Good morning, members of the board.
Okay, who's this?
Good morning, members of the board. I'm Michael Cunningham, and I will be representing the division in this enforcement matter. And let me just go ahead and pull up a PowerPoint presentation here.
Michael and John, I don't know if you
Mike?
saw everyone in or not. You're kind of
Are there
cutting
people?
out.
Hmm.
Well, I'm getting bad reception from everyone, so I don't know. But do we need to swear anybody?
Yes,
Yeah,
and I do not believe the operator is present here this morning.
Yeah, is the operator's present and you're there, so I need to swear both of them.
Hey, John,
Stefan Mosovic, is that right? Is he there?
Mr. Singletary,
Yes.
would you like to try to jump off and come back on again? Because we can't hear you right now.
Yes.
Okay, you want to take 5 minutes
Okay.
maybe?
All right. Well, say, is there anybody that can keep this? With Lauren, you go ahead and keep this thing going and I'll come back on.
Sure, if you need us to, or we could take a little 5-minute break.
Yeah, why don't we take a 5-minute
Okay.
break, Mr. Singletary, and we'll just try to get you back on.
Okay. Yeah, let's do this. All right. So sounds good. All right.
Okay. All right.
Calling
thanks,
in
everyone.
might be clearer too. It might be a little more
Thanks.
consistent, you know.
Thanks, everybody.
Hello? Anybody hear this?
Yes, we can hear you.
Is that better?
seems like it might be. Yeah.
Yeah, for right now, it sounds much better.
Okay, well, if somebody's still, we'll take another 3 or 4 minute break then, if that's all right, if they're gone. Unless everybody's here, then we'll continue.
Let's see here.
Looks like everybody's
It
here.
looks like everybody's here.
Okay, let's go. Who was up at the time?
I'll be presenting this
Michael,
item this morning.
Okay, Michael. Yeah, go ahead.
I'll try to tell the truth. Thank you.
Okay. And then who's, and you said the operator's there, is he here?
No, I do not believe the operator will be here this morning. So I will,
Let me make sure. Is Stefan Mosovic, is that right? Is he here? I'm just clear, I want to clear the air. Okay, go ahead, Michael.
can everybody see my screen okay?
You bet.
Yes.
All right. Mr. Chair, members of the board, again, Michael Cunningham representing the division in the enforcement matter for the Big R Pit, permit number M1988-052, operated by Colorado Farms LLC. This matter has come before the board this morning for consideration of a violation, civil penalty, cease and desist order, and corrective actions for failure to comply with the conditions of the order for violation number MV-2021-021. Just a brief permit summary. The Big R Pit is a 110 construction materials site located in Elbert County, approximately 13 miles north of the town of Elizabeth. The site is permitted for 9.9 acres. The commodity that was mined is sand and gravel. Land ownership, I would like to note that the land ownership has changed since the last time we were before the board. The property had been owned by the operator, Colorado Farms LLC. Recently, the new landowner, Lakeport CF LLC, reached out and notified me that they are a new property owner. According to Lakeport, they took title of the property in December of 2020. I was able to verify through the Elbert County Assessor's Office that their records indicate they're the owner as of October of 2021. So I just wanted you to note that we do have a new landowner out there. As of yet, we have not received an updated legal right of entry for the new operator. So that is an outstanding issue, but very well may be moot after today's hearing. The post-mining land use is pasture land and/or general agriculture, and we currently hold a financial warranty in the amount of $18,642, which is not adequate to complete reclamation at this time. Here's just a general site location map showing you where that site is north of Elizabeth, denoted by the yellow star. I'll briefly summarize the current site conditions. The north pit was backfilled in 2014-2015 timeframe, still needs to be retopsoiled and revegetated. The site contains a large topsoil stockpile along the north permit boundary. The vegetative cover of the north pit does not have desirable grass species, but primarily consists of weeds. In addition, there's a south pit area that is not backfilled. There's some minor high walls up to 15 feet in height with 1-to-1 slopes that would need to be knocked down, as well as a small topsoil stockpile on the southeastern edge of the pit. At the time of the last inspection, there was a small material stockpile remaining just north of the south pit that could be used for reclamation. The operator had imported 20 tons of inert topsoil, and again, that is there and available for use in reclamation. Here is just an aerial photo showing you what that site looks like. The permit boundary is in red, and you can see some of the high walls that need to be reclaimed have been outlined in yellow there, as well as some of the topsoil stockpiles present on the site. I'd like to just remind the board of some of the chronology that led us up to this point. In February 3rd of 2021, we conducted a site inspection. And as part of our routine monitoring inspection, we calculated the financial warranty and determined that it was not adequate at that time. On February 5th, we issued the inspection report along with our updated bond estimate, and we provided the operator with a full 60 days to review that bond estimate before we initiated a surety increase. On April 6th, the operator submitted a corrective action response and indicated their acceptance of the bond estimate that the division calculated. From that point, we initiated a formal surety increase, and notice of that was sent on April 20th, 2021, which started the 60-day time frame within which the operator needed to provide us with the additional financial warranty in the amount of $32,990. That 60-day due date was June 19th of 2021. On that deadline, we had not received the financial warranty documentation. We sent out a notice of past due financial warranty increase to the operator on July 1st, 2021, and essentially gave them 3 more weeks to provide us with that increased financial warranty. That second deadline came due on July 23rd, and again, we had not received any of the financial warranty documents from the operator. As such, on August 12th, we sent the operator a notice of possible violation, and we scheduled that matter for a hearing for failure to post that increased financial warranty within 60 days. At the September 22nd, 2021 board hearing, the board found the operator in violation for failing to post the additional financial warranty within 60 days of the date of notice of adjustment. On November 20th, 2021, the board ordered the deadline for submitting an increased financial warranty in the amount of $32,990. I would like to note that on January 5th, actually, let me back up, excuse me, on January 5th, the division sent the operator a reason to believe a violation exists, a notice of today's board hearing for failure to comply with the board order that was issued from that September 22nd hearing. And I do want the board to be aware that on January 25th, the operator did reach out. They expressed their desire to get into compliance, and they did hand deliver a check in the amount of $32,990 to our office. Unfortunately, that check had been issued 6 months prior to the date that we had received it, and therefore our accounting department was not able to accept it. Essentially, it was an expired check. It appears that the check was issued around the time frame when we initiated that surety increase in the year prior. But for some reason, we were not provided with that check until, again, January 25th. In addition to the expired check, we didn't receive any of the necessary financial warranty documentation. So it was nice to get the check, but in addition to the check, we needed a couple of additional forms. I communicated this to the operator immediately after learning from accounting that we could not accept this check. We told them in writing what needed to be provided to the office in order to cure this default. And as of today's date, I do not have a replacement check or any of the additional financial warranty documentation. With respect to staff recommendations, staff recommends the board find the operator in violation of CRS 34-32.5-124 for failure to comply with the conditions of the order for violation MV 2021-021. With respect to the cease and desist order, staff recommends the board reaffirm the cease and desist order issued by the board at the September 22nd, 2021 board hearing, which prohibited any further activities on the affected lands, except those activities approved by the division in writing as necessary to comply with the conditions of a board order, prevent damage to offsite areas, complete reclamation, or to protect public health and safety until the corrective actions have been resolved to the satisfaction of the division. As for civil penalties, in this matter, the board previously imposed a civil penalty of 61 days at $100 per day for a total civil penalty of $6,100. All but 500 of the total assessed civil penalty was suspended if the operator complied with the corrective action in the time specified. Staff is not seeking any additional civil penalties in this matter, but staff recommends the board affirm the suspended civil penalty of $5,600 is now due and payable. With respect to permit revocation, pursuant to CRS 34-32.5-124, parent 6, parent A, upon a determination after a hearing that a violation of a permit provision has occurred, the board may suspend, modify, or revoke such permit. Staff recommends the board revoke permit number M1988-052 pursuant to CRS 34-32.5-124, parent 6, parent A. With respect to finding the financial warranty subject to forfeiture, pursuant to CRS 34-32.5-118, parent 1, parent A, and parent B, a financial warranty shall be subject to forfeiture whenever the board determines that one or more of the following circumstances exists. Either the operator has violated a cease and desist order entered pursuant to section 34-32.5-124, and if a corrective action was proposed in such order, has failed to complete such corrective action, although ample time to do so has elapsed, or the operator is in default under a performance warranty and has failed to cure such default, although the operator has been given written notice and has had ample time to do so. In this matter, staff recommends the board find the financial warranty for permit number M1988-052 subject to forfeiture pursuant to CRS 34-32.5-118, parent 1, parent B. That concludes my presentation. There is one additional thing I would like to note for the board here. Let me stop sharing my screen. And that is with respect to the new landowner. They indicated, in addition to taking title of this property, that they have submitted a planned unit development to the Elbert County Commissioner's Office, and they hope to see 1,200 homes built on that property and some of the surrounding properties that they own. So I just thought that was important for the board to note. Certainly, we never want to be in a situation where we revoke and forfeit a site that does not have an adequate bond, but it seems like there's some other activities occurring at the site which ultimately might negate the need for reclamation, just depending on whether they get approval for this development and then when that moves forward. And with that, I'm happy to answer any questions from the board.
Any questions?
Yeah, this is Lauren. You know I have one.
Well, Michael,
oh, I'm sorry. There's some bad feedback there. My question is about the ownership change, right? So it sounds like a completely different land use is being suggested for the site down the road. Obviously, it still needs to be reclaimed in order to kind of get to the point where you could build homes on it. So I think that reclamation requirement still makes a lot of sense. Gosh, sorry. I guess I'm a little confused on the payment. It sounds like they had it, but they never submitted it. Is there any opportunity for them to reissue that check and submit it and kind of put this behind them?
Absolutely. And that's what's been communicated to the operator, is that, any point in time up until today's board hearing, had we received the outstanding financial warranty and financial warranty documents, we would have likely continued this item to the next month to be able to review and approve those or withdraw the matter entirely altogether. So there is an opportunity, even at this stage, if the board decides to revoke the permit, there is a process for reinstatement. The operator would just simply need to provide us with those missing documents. So yes, that's been communicated to them. There is some additional complexity with that financial warranty. I don't hesitate to speak too much to it, but in talking with the new landowner, it sounds like they were the third-party financial warrantor for this operator. In other words, they had provided that check well over a year ago. Again, why it was not delivered to us, I can't answer that, but I believe that some of the dealings between the new landowner and the operator is what led to them taking title of this property a couple years ago.
Okay, so there's some things in the background there. Okay, all right, well, thank you for that clarification. Sounds like we got a path forward.
any other questions? If not, is there a motion?
I'll work through a motion here, Mr. Chair. I move that the board find the operator in violation of CRS. I'm sorry, this is Excuse me, I'm sorry. 1 second. Okay, in regards to file number M-1988-052, I move that the board find the operator in violation of CRS 3432.5-124 for failure to comply with the conditions of the order for violation MV-2021-021. That the board reaffirms the cease and desist order issued by the board at the September 22nd, 2001 board hearing, which prohibited any further activities on the affected lands except those activities approved by the division in writing as necessary to comply with the conditions of the board order, prevent damage to offsite areas, complete reclamation, or to protect public health and safety until the corrective actions have been resolved to the satisfaction of the division. That the board affirms the suspended civil penalty of $5,600 is due and payable. And that the board revokes permit number M-1988-052 pursuant to CRS 34-32.5-124, parent 6, parent A. And that the board find the financial warranty for permit number M-1988-052 subject to forfeiture pursuant to CRS 34-32.5-118, parent 1, parent B.
I'll second it.
Thank you. It's been moved and seconded. Any discussion? Hearing no's, all in favor of them signify by saying aye.
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 Those opposed, same sign. Hearing none, the motion passes. You know, let's take about a 10 break. I'm going to shut it and I apologize. Just be at best today. So let's wait. We'll go to 10 after 10 and then we'll come back if that's all right.
Sounds good. Thanks.
Everybody back?
Looks like we're just waiting for Miss Duncan. Oh,
Okay.
I think she just popped on. Nope, not yet.
Okay.
All right, Mr. Singletary, we have everybody.
Okay, moving along to item number 8, I mean 9, I'm sorry. Item number 8 was is consent, but item number 9, enforcement hearing seeking relief and a waiver of civil penalties, Adams County. Who's us from the staff?
Jared and Patrick.
Okay. Do we have people that we need to swear here?
Think so, yeah.
If there's people that are going to testify on this, please identify yourself and swear to tell the truth.
Hi, this is Rita Rita Connerly and Colin Walker with the law firm of Fairfield and Woods are representing the Kelly Trucking, and Cal Kelly as well as a representative here on behalf of Kelly Trucking, and we swear to tell the truth.
Cal Kelly with Kelly Trucking. I swear to tell the truth.
Okay, anyone else?
Eric Carlson with Foster Graham, Milstein and Kalisher, representing the objector, Danko Holloway. I swear to tell the truth.
Okay.
Jared Ebert with the Division of Reclamation, Mining and Safety. Patrick Lambert with the Division of Reclamation, Mining and Safety.
And Russ Means with the Division of Reclamation, Mining and Safety.
Yes, ma'am. Go ahead.
I'm Danny Danko. I swear to tell the truth.
Okay, thank you. Okay, Jared, I think, are you the one that starts this?
Sure, I can kick us off. This is for file number M2019-053 for the former Watkins mine operated by Kelly Trucking. This is a hearing for consideration of a motion for relief and a waiver of civil penalties filed by Kelly Trucking on January 11th, 2022. So just real briefly to bring the board to kind of speed, if you recall from last meeting, we were in front of the board for a hearing to consider the application they had filed, and we recommended denial of that application, and the board upheld that decision. Back in 2019, this site was found in violation for mining without a permit. The board ordered the operator to get a permit as part of the corrective action, and they did submit a permit application. We went through a year and a half, almost 2 years of review. And then obviously we denied that application, or we ended up moving to deny that application. So they were unable to comply with the board's order, and therefore the civil penalties that the board had suspended, during that original enforcement hearing are now due and payable. And their motion, Kelly Trucking, is for relief of that. That's kind of teeing it up. Let me know if you have any questions.
Any questions of Jared?
Yeah, just a quick one. This is Lauren. To clarify, we're talking about $5,849.60 that was due and payable, or the original 34,000?
It's the 34,000.
Thank you.
Mr. Chair, this is Jeff. You get on the division, if I can weigh in as well.
Okay, Jeff, go ahead.
Ms. Duncan, more specifically, they're seeking waiver of the $29,000 civil penalty amount that the board suspended in that 2020 order. So they have paid the approximately $5,800 penalty. So this is just dealing with their request to vacate that remaining $29,000 amount.
Okay, thank you so much.
Any other questions? And I guess I would go to Kelly Trucking for their
Good morning.
presentation.
Good morning, board members. We have submitted to you the motion for relief from and waiver of the civil penalties in the amount of $29,000, which were suspended by the board's order dated January 13th of 2020. As outlined in the motion, and Kelly Trucking has complied with all of the conditions and corrective actions set forth in that order, but for the inability to obtain approval of the application from the board because of the county, the lack of a legal right of entry as determined by Adams County and the city of Aurora. Based on all available public information and even as set forth in your record on page 173, Adams County's initial reaction was that that permit for Watkins Road would be available, and Watkins Road was a public right-of-way. There was a road petition pursuant to the Public Highway Act in 1887 approved pursuant to the process then in effect. So, and all available county, city, and state records indicated this was in fact public. Even the objector's deed of record at that time, as well as the county assessor's records for the property. So for those reasons, we're requesting the board's favorable consideration of the motion, and will be available to answer any questions that may be presented.
Any other comments from the Kelly people? If not, then I'll hear from the objector.
Good morning. Good morning, Chair, honorable members of the board. Eric Carlson with Foster Graham, Milson and Kalisher on behalf of Danny Danko Holloway. We respectfully request that you deny Kelly Trucking's motion for waiver of the suspended fees today. You know, as you know, one of the conditions of the suspension of fees was obtaining a proper permit for this mining activity. It simply wasn't done. It simply cannot be done. There's not legal access to this property that was the subject of your hearing last week. You know, in addition, this case has drug on over 2 years. So there's been significant and continued negative impacts to my client's property over that time. The civil penalties derived from Kelly Trucking's improper mining activities. Nothing can negate that Kelly Trucking improperly mined the subject property. Furthermore, failing to obtain a DRMS permit shows just how egregious their mining activities were. No permit, no legal access, yet Kelly Trucking mined away. The improper mining has caused negative impacts to our client's property. 30 to 40 trucks every 90 minutes all summer long, a large hauling road constructed on our client's property. It eliminates our client's access to a portion of her property. Because this road exists, there are continued negative impacts, trash dumping, culvert installation, continued traffic that was not there prior to the illegal mining activity and construction of the road. So due to Kelly Trucking's client, our client has had to expend an incredible amount of effort and resources to defend her property rights. The thought that Kelly Trucking could be left off the hook and released from their civil penalties when our clients have been forced to expend resources and efforts to defend their property rights is entirely unjust. We respectfully request that you deny Kelly Trucking's motion for relief from the civil penalties in order to pay the full amount of the suspended penalties. Thank you for your time this morning. We're happy to answer any questions at the board's pleasure.
Any questions or any other comments from the objectors?
Comments?
So this is Lauren of,
Wait a minute, I
I'm sorry,
think.
go ahead.
Go ahead, objector.
There are other things that they did not comply with. I mean, they were supposed to get permits from both the city of Aurora that they didn't get from the city of Aurora and the county, Adams County. They did not receive those permits. They did not have, the land was in Phyllis Kelly's name when they started the mining. Then it went into a personal representative deed to John Kelly. John Kelly did not sign that deed over to Kelly Trucking until after the mining had finished, which was in 2020 when it went into Kelly Trucking. So there wasn't even a warranty deed while they were mining. It was just in a personal representative deed's name. So there wasn't even a warranty deed to back up what they were doing. They were under a contract with the city, with the Denver International Airport, which also put them in contract that they were legally responsible to get all of the permits in order to fulfill their contract with DEN to complete their contract. So they were in violation of DEN's contract by not getting any of those permits. I mean, they've been skating on getting all of the permits the entire way, and they have violated my constitutional rights as well as my co-owners and the neighbors that I have. And they've disrupted the peaceful nature that we've had for many, many, many years. And to go back and say that first it's Adams County's land, and then they said, or right of way, and then they said it's Aurora's right of way. And now they're saying it's something that happened in 1887, I think is what Ms. Connolly just said. Hey, they're just grasping at straws. And they've made millions on their DIA contract without paying. Right now, they're paying just under $6,000 for this.
Any other comments from the objectors? Any rebuttal or comments from Kelly?
Yes, thank you. So I'll reflect back again on the motion as well as the board's order of January 13th, outlining the corrective actions which are before this board. And it was cease and desist further mining activities. You have an affidavit attached in your packet that affirms that those mining activities were timely ceased. An application to obtain a 112C reclamation permit was timely filed, satisfying condition 2 of the order. Condition 3, obtain approval of the application, has not been satisfied, and I'll go through a little bit of the reasonableness of believing in good faith that that application would be obtained, and payment of the civil penalties of $5,849.60, which was remitted to the division. As to I think a lot of this is certainly outside the purview of the division, but if you remembered our board hearing previously in January, there was before you a road petition on page 162 of that record. And the petition was to create a public highway on Watkins Road. That Watkins Road segment applied to both sections 1 and section 6, which are the applicants and the objectors' properties. The viewers were appointed on, as you can tell on page 164 of that record. Notice of the creation of this public highway on Watkins Road was provided on page 165. You'll see that. And 30 feet was taken on both sides, a 30-foot width of right-of-way was taken from sections 1 and section 6, the objectors and the applicant's properties. They were paid, not much at that time, but $14.50, as the records indicate, for their property, and that's shown on page 168. They complied with the law in effect in 1889. On November 12, 1889, the public road was deemed created. Notice was given of the opening of the road as a public highway. And with that 90-day notice, the road, Watkins Road, was then opened in February of 1890. In your packet, and since that time, you will see that the state records from the Colorado Department of Transportation identify this road as a local unimproved road. The deed of the objectors, the assessor's records, and Adams County records, in fact, showed that Watkins Road was a public road. The city of Aurora annexed Ms. Danko's property, and she, as a condition of annexation, was required to give additional right-of-way for Watkins Road, so that Watkins Road would eventually be 200 feet. So 100 feet was going to be on the west side of the objector's property. Adams, in addition to the Adams County records and the state records, the city of Aurora, as you see appended to the motion, showed via all the plat maps that in fact Watkins Road existed and took, as the road book pages show, 30 feet on the west side of the center line of Watkins and on the east side of the center line of Watkins. The applicant has proceeded in good faith to satisfy all of the conditions. I will say that they are going to continue working with the governmental jurisdictions to identify the road right-of-way and come back for a permit for this operation or for potential continued operations. Based on that good faith and the record before you, we submit that we had no idea, the applicant had no idea that Watkins Road was not a public road. And since this initial decision from the governmental jurisdictions, we will continue to work with them on that matter. And we respectfully request your favorable consideration of this motion. Thank you.
Okay, any questions from the board?
I have comments.
I gave you a comment before. I'm going to the board now. Board, do you have any questions before I close the hearing?
Here's a letter from Adams County dated November 13th, 2020 from Patrick Lindbergh. He's the right-of-way supervisor for Adams County that provided those documents to the RMS stating that a thorough investigation has been done, and it explains in those documents that Ms. Connolly just went through that those documents were used to prove that my portion, that Watkins Road never went through from 72nd to 62nd Avenue. In addition to the survey that Kelly Trucking had done in 2017, their own survey said that Watkins, in order to prove that Watkins Road was along that way, had to be further documentation. And the other documentation that they've submitted to DRMS is from the internet, and in Adams County and the city of Aurora have the disclaimers that it cannot be used as legal documentation. It is for graphic use only.
Okay, thank you. And that's, I let you get away with something there, but is there any comment from the staff?
Mr. Chair, thank you, Jeff. Here on behalf of the staff, I'll keep it brief because this really is a narrow scope request to the board, relevant really only to the 2020 board order related to civil penalties. A couple of facts I wanted to raise with the board or make the board aware of. The civil penalty that was assessed back in the 2019 hearing issued in the 2020 board order, it was the minimal amount of penalty authorized under statute. So it was $1,000 per day for 34 days. The range, as the board's aware, is $1,000 to $5,000. So this is not, in the division's opinion, a significant penalty amount. It was assessed at the lowest amount possible for the days that the division sought violation, those 34 days. The other thing that Ms. Connerly addressed is the board order itself and the express language that Kelly Trucking was required to not only submit the permit application, but obtain a 112C reclamation permit from the division. As this board's aware, because it denied the permit last month, they failed to comply with that provision of the order. Therefore, I think that any request to vacate based on good faith or good efforts really is not relevant. They failed to comply with the board order. I think that it's a slippery slope if the board starts forgiving penalties based on good faith efforts. The facts here show that they failed to comply with the board order to obtain that permit because of this right of entry issue. So before the board today is not relitigating the right of entry or adjudicating any rights related to the road. It really is a factual determination as to whether or not Kelly Trucking complied with the board order, and they did not because they did not obtain approval of a 112C permit.
Mr. Fugate, so where are we sitting in condition of the land? What's our liability with the land and the condition it's in now?
I'll try to address that, although the division has not conducted an inspection in recent months, as was discussed a little bit at last month's hearing as well. Because the permit was not issued, there is no jurisdiction for the division or board to force reclamation of this road. So its condition is how it's going to exist. I believe that Ms. Danko-Holloway testified that there is still some access issues, that she's not able to access or use the full length of the road. But that is unfortunately something that cannot be addressed through our process because it's no longer within or never became part of the division or board's jurisdiction because of the denial of the permits.
Any others from the board? Joe? No questions? Okay, well, I'm going to close the hearing. Is there discussion?
Yeah, this is Lauren. I think this was a challenging decision last month because I think we like to see reclamation completed where it needs to be completed. It sounds like there was an issue. That issue now has impacted neighboring properties or access through other properties. It's never that we like to say, oh, well, we can't do anything and that's too bad. Unfortunately, I do think we do have a narrow scope here, and I have to appreciate Mr. Fugate's summary of the issues here. I think that does really help with today's conversation. It sounds, paying the fee back to the division is not going to make Ms. Holloway whole, but it is certainly a tool to say, this was a problem that didn't get addressed correctly in the first place. and not a way that we like to leave land or neighbors of any mining operation. So from just a discussion standpoint, my opinion here would be to continue to move forward with the additional 29,000 remaining. I think that would kind of drive home the point of responsible mining being what we support here at the board, and highlight the issues that were not addressed properly the first time. And love to hear other thoughts, though.
Any other discussion? I
Do you all agree with
apologize
that
for
sentiment?
I do believe operators need to be held accountable. I agree with you, Lauren, that it's a mistake gone wrong. We need to hold them accountable for that, so it doesn't happen again.
Yeah, I feel the expectations were clearly stated about what needed to be addressed, and it is a slippery slope to not comply when the time has come to kind of put everything on the table and see where we're at on a status check. So agree with Lauren and Jill there.
Yeah, and I mean, I see it from the operator standpoint. The challenge is getting that access and potentially initial confusion over thinking that they had it. That's definitely something that happens with assessors' websites, right? Like, I live in Gilpin and we are not close to what the assessor has on the GIS. So if anything, maybe this is an opportunity for other operators to look to this and say, okay, let's double check all of our access. Let's double check all of our right to entry before we start any sort of mining operation. And an example of following through on initial judgments of the board as well.
Agreed. Yeah, property line disputes are all too common, unfortunately. But
yeah,
it is the way of our world.
Okay, any other discussion?
Is there an opportunity to speak?
No, the hearing's closed. So there, would Lauren, you want to put together some kind of a motion to reflect what your thoughts are?
Here, give me 1 second here to kind of read and summarize. Apologize. I'm thinking and trying to speak at the same time. Okay, for file number M-2019-053, I move that we decision and impose the civil penalty of 34 days of violation for a total of $34,000 with the to include the $5,849.60 that was already paid, for a total payment of $34,000. And if someone could please check my language, I would really appreciate that.
Lauren, you may just want to include something.
Charles, is that?
Yeah, I was just going to say, you may want to include some direction from the board about the motion. So either denying, and then what you've got crafted fits well in there. So.
Okay, thank you. Yes, and in addition to my previous statement, I would move that we deny the motion for relief from and the waiver of civil penalties.
Is there a second to that motion?
Second is Patrick.
Okay, thank you. Any additional discussion? If not, we'll have a vote. All those in favor of the motion signify by saying aye.
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 All those opposed, same sign. Hearing none, the motion is. Okay, moving on to item number 10 on the agenda. Staff information.
Get things squared away here. Thank you. I'd like to start off here. Today's I'd like to present to the board a guidance document on designated chemicals and a designated chemical list, which we'll refer to as DSL. We sent to you a copy of the guidance document along with our initial DSL list and this is for hard rock metallurgical processing. So these documents will be available on our website after today's presentation to you for use by applicants, the public, and staff. Some of the board members may remember a while back, we had a small mill operator and consultant pushing the fact that we did not have a DCL list. So therefore they didn't have to provide the division or the board information on the chemicals that they were using. That argument the board found had no merit, as the rule and policy have always required submittal of the information for review. However, in order to kind of close that loop and to be as clear and transparent as possible, we worked on this guidance. We actually started looking at this list several years ago, but it kind of fell to the side and that. But after that recent hearing, I asked Senior Michael Cunningham and EPS Lucas West to come up with a guidance document and our initial list. And so thanks to their hard work, we have the documents and stuff that are before you today. And I want to make clear some stuff in that. We also ran this by a few operators to get some feedback on it as well prior to bringing it before you. Currently, the definition for designated chemicals reads from 3432-101, parent 19, that designated chemicals are toxic or acidic chemicals used within the permit area in extractive metallurgical processing, that the use of which at certain concentrations represents a potential threat to human health, property, and the environment. Staff has done some edits that the board will see in rulemaking here in the near future that will clarify what is required for submittal and review by the staff for designated chemicals that will further help clarify this issue and stuff for anybody that's involved. The guidance is designed as a discussion starting point for new applicants and operators that are proposing metallurgical processes. That may be milling, it could be leaching, or any process that uses chemicals for extraction. One of the things and stuff that we were looking at is trying to have it open-ended as new technologies become available. We'll be able to take a look at those and stuff and evaluate it under this guidance and stuff and maybe add to that as we move forward. So, but the one thing it's not designed for is for the division to review other chemicals used in the everyday mining work or uses. There are some instances and stuff where there's actually some chemicals that may be used in like a water treatment plant at a facility in that may also be used in metallurgical processing. So we're focused on the processing, the water treatment part of those and stuff, chemicals or those kind of issues and stuff and that are outside of our jurisdiction, as the statute and the rules are very specific that it's regarding the extraction processes and nothing more. I'm going to try to share with you the DCL list here because I think it's kind of interesting. Let's see if I can get it to come up here. Did it go? No, that didn't do it. Can you now see that the list?
Yes, we
disappeared.
can.
Can you see it? Stop share. Let me go back here and stuff. I don't know what. We'll do this again. Share. So the list and stuff here and stuff, the general public and stuff will be able to see just the front list and stuff that's here, listed the chemicals and stuff that we have on the list. Staff will also have access to the back tabs and stuff here that actually have all of the information regarding the chemical names, their trade and other uses, their health hazards, the CAS numbers and everything else. So that we have questions as to why these are on the list, we can actually go into a deeper dive. And then of course we have a third tab and stuff that also has additional information and stuff on hazmat and other issues and stuff there. So the intent of this is actually to, this is going to be a living list. And what we're going to be doing and stuff is as we evaluate applications and permits, actions and stuff and that where we have additional chemicals and stuff, we'll keep adding to this as it goes along. So the idea and stuff here and stuff and that is that with the background information and stuff and that we'll be able to provide as much guidance. And having had them pre-evaluated and stuff, if somebody comes in and says, well, I want to use this, we can come to this list and say, we have looked at this and it's on our list and stuff. So that has to be part of your designated chemical list and stuff for your application or whatever we're working on. So this is an informational presentation. So we're not asking for board action at this time and stuff. We just wanted to let you know some of the things and stuff that we're putting out there and stuff to help the applicants, the general public and staff and stuff on some of these more complicated issues. So we would like we feel that your feedback is important and would appreciate any comments or questions and stuff that you have at this time.
What does the color coding indicate?
It's not, the color coding is stuff for me and stuff, and that's a little hard.
Okay.
But there's a couple of those and stuff in that we have that are Lucas, are you online? And that he could explain that better than I can and stuff.
Yes, he's not online anymore.
Oh, he disappeared on me and stuff like that. Those two and stuff like that, he just had those outlined and stuff and that on our initial list and stuff and that as things and stuff that are authors and stuff like that we were looking at and stuff initially and stuff. We just didn't change the color on that one. So.
Okay, cool, thanks.
So
go for it, Joe. No, go, please.
Go ahead.
So you mentioned that this is a living process. What does it take to get on the list, especially new products that are?
Well, that's if an applicant comes in and says, well, we're going to start up a mill and that under the rules and stuff, they're supposed to submit to us a list of all of the chemicals and stuff that they're going to use in their processing and stuff for in that milling process, leaching or whatever. We're going to go be able to say, look at this list and say, is it on here? If it's not, then we'll be able to ask for additional information. And we'll also be able to go in and look at the EPA list and other lists and stuff and that to garner the information we need to determine whether it's something that should be, is it acidic or toxic or something in some nature and stuff that needs to be put on this list, so that in the future, if somebody else were to come in with a similar chemical or whatever, we can say, we've already evaluated that, that's on that list. And a lot of times we get pre-consultations where somebody will come in and say, hey, we're going to be putting together an application for a mill. What kind of chemicals and stuff and that are typically on that? We can point them to this list and say, if you're using any of these, you need to be aware and stuff of the designated chemical list. And this all kind of helps predicate the discussion and stuff on designated mining operations. If you have designated chemicals and stuff in that, then we have to have a discussion and stuff on whether you're a DMO or not.
Mr. Means, thanks for this. The question I have is it possible that some of these chemicals might come off the designated list? And if so, how how is industry informed of that might be utilizing something that comes off the list?
Most of these and stuff and that are there and stuff are pretty straightforward and stuff and that on their environmental impacts. So we haven't crossed that bridge and stuff. If somebody were to come in and say, if say the EPA were to pull it off the list, I think and stuff what we would do and stuff and that is we would reach out to the operators and note and stuff and that particular chemical and stuff and that has been delisted, if you will. And then we have the ability to do that. But most of these are used in conjunction with everything else. So pulling one chemical off and that's not necessarily going to change the designation for like DMO or anything like that. But we do have that ability and stuff to reach out to operators and stuff and that are DMO and say, if you're using these and stuff and that, then be aware and stuff that it's been pulled off the list.
Russ, I am back on. I apologize. Oh, sorry.
Nope. Good. Glad you're here.
Yeah, I apologize I switched over to the YouTube feed to try and free up some bandwidth because I could tell there was some glitchy issues. But if you'd like, I can expand on Patrick Ortiz's question a little more.
Yeah, Lucas, the question is we have there's two of them and stuff here that are a different color than the other ones. So
yeah, so the color coding on the chart really just indicates the light red hue is chemicals that we evaluated and are definite designated chemicals. The two that are in orange are probable. They have probable health effects. Not the SDS sheets, the safety data sheets associated with those chemicals detail some hazard effects, not necessarily to humans, but to aquatic life or vice versa. So they're what we're designating as probable, and we would evaluate applications based on their use and concentrations of that chemical. And then there is one on there that is green, and that's hydrated lime, which in of itself is not necessarily in small quantities. It's not necessarily hazardous, but some of our bigger operations have a huge silo of hydrated lime. And if there was a failure of something like that, then that could have effects on the environment. So we went ahead and included that on the list, even though in small quantities, it's not considered toxic. But if we had a major spill, it very well could be.
Thanks, Lucas. I didn't remember that. So thanks.
Yes,
thanks for that.
And I'll be able to answer any other questions that come up because I'm back on. I'll stay put.
All right.
Awesome.
All right.
Thanks. That answered one of my first ones. I guess I have a couple of them, so bear with me here. How do you make that differentiation between this is a small amount on a site and this is a large amount on a site? Is there a cutoff in terms of tonnage or barrels or whatever, or gallons or?
In the actual memo and stuff, and we talk about bench scale amounts and those kind of uses and stuff there, and that's where part of the discussions and stuff for the operator would be at. So, and quite honestly, so it depends on the toxicity of the chemicals and stuff. Some of this stuff in that a 55-gallon barrel and stuff is not going to equate to much of anything. However, and stuff in that, if it was, several hundred or several thousand gallons or something like that, then that exponentially kicks that up there. So that's part of the discussions we would be having with the applicant or the operator is how much are you having on site? What's the toxicity of that? Because there are certain things and stuff there, obviously, that in 20 or 30 gallons and stuff on a small site and stuff are going to have a greater impact and stuff than say at a larger site like a Climax or something like that, where they have, huge amounts and stuff for that and that. So that's all part of that evaluations and stuff and that with staff and the discussions we'll have with them.
Okay, that makes a lot of sense, right? Because, if it's bench scale for a Freeport, they've got their own labs versus somebody that is just a small operator in the woods and kind of figuring it out as they go. So that I'm glad that's kind of person to person. How is this translated for prospecting sites?
It would be the definition of a designated chemical is related more specifically to permitting the prospecting. However, and stuff, if we had somebody coming in with prospecting and stuff and they were trying to do some of these things and stuff, we would be having a serious discussion about whether there's a permit required up front rather than a prospecting operation. So I think that would be one of the first questions we would ask, and that is, for one thing and stuff, you're not allowed to under prospecting and stuff to sell materials. You're just in the investigative phase.
Right.
So why would you be needing these particular chemicals and stuff and that, granted, and a pilot program, project or something like that should be covered under a regular permit, not a prospecting permit.
Okay. Okay. So again, that might move you into permitting, and again, you're working with the operators on that to really nail down what they're doing and what they're using. Let's see. The other one I had was something that came up, I think, at that hearing that you referred to earlier, that he was using the chemicals underground and not on the surface in a milling building or a milling site or what have you. His mill was underground in his mine. And so he wasn't sure if he needed to outline them to you or something like that. There was a confusion about where he was doing the work and how that impacted the designated chemical.
Part of the a lot of our work and stuff and that is regarding the surface work and everything else. But when they start doing milling processes and stuff under statute and that that's requires a permit and that. So it doesn't matter where the milling operation is and stuff, whether it's on the surface or underground, it's still a milling process and stuff that has to be covered by our permit. We have, that was a very small one. We have a very large one and stuff in that, actually the Ray Silver mines and stuff in that. They have a very big mill and it's all underground, and we have jurisdiction over that. So part of that too is, while they may do their processing underground and stuff, that there's a potential for groundwater impacts and stuff from those chemicals being there, or if they're pumping stuff to the surface and stuff and that, then those chemicals have a potential and stuff to be released to the environment in that way as well. So, but by statute and rule and stuff and that, the metal processing and stuff has to be covered under our permit.
And then I have a follow-up on that, right? You mentioned groundwater, but I'm thinking about if you're underground, you potentially are working in a semi-enclosed space, and that might change some of the safety associated with these chemicals and maybe take something from not that big an issue to a larger issue if you're inhaling it in an enclosed space. I assume that's, again, kind of covered under your conversations with the operators on how and where they're using these chemicals.
It's part of the conversation, but it's not part of our jurisdiction. And that's the tricky part and stuff there and stuff is the actual worker safety and stuff that's covered by MSHA, or if it's in a laboratory setting and stuff, it's actually OSHA. So we can bring those things to their attention. We want to bring those to their attention and stuff and that, but we're focused in on the environmental impacts and the hydrological impacts and stuff to the use of those chemicals. And in our guidance and stuff, that's what we make sure everybody understands. We're not looking at the impacts and stuff to workers; those are covered by other jurisdictions. So, but it is a very important aspect that we can bring up.
Sure. And then two more, and then I promise I'll stop talking here. The first one that you've already kind of mentioned is, how would you go about informing industry, kind of on a large scale, rather than operator to operator?
As far as something being on the list or taking it
on or off.
The great thing and stuff in that about some of the processes and stuff that we have in place and stuff with working with operators is it's called MailChimp. And if we had some kind of a major kind of something coming off the list, we can put it out there. If we were to add things to the list or whatever, we could certainly send something out to operators, specific operators and stuff. We can narrow it down to like all our DMOs saying, just so you know, and we'll do that. We'll send this and say, hey, here's a list, and we're going to be building on that list based on some of the information that's in some of the other permits that we have and stuff. So this list is going to be expanding, and if we add something, then certainly and stuff, that would be a great thing and stuff for us to do and say, we've reviewed an application, and that application and stuff included X, Y, and Z. And so we just want you as an industry and stuff to understand that, and that's on that list now. And also we have monthly meetings with the Colorado Mining Association, and that's a good avenue and stuff to throw things out and stuff there and disseminate that information to the industry.
Okay. And then not being totally familiar with MailChimp, the only time I think I've used it is a survey 100 years ago. Is it email and a paper copy going out?
Usually it's just an email notification. And as we're working on e-permitting and stuff, there'll be other ways and stuff to do that and stuff, sending out notifications. But we could send out hard copies and stuff to everybody. I think we can attach a PDF to that. If I remember correctly, we can attach a PDF and say, here's your current list for, March of 2022 or whatever and stuff, and that just as a informative bulletin or something along those lines.
Yeah, I think that would be really helpful. I'm just thinking about folks who don't maybe have great internet access where they're working or aren't in front of a computer weekly even because they're inside of a mine.
Yeah, you bet.
And then last one, that's an easy one. I just skimmed the memo itself this morning. Is there language on there that says something like this is not a complete list? That list is what you said of how it's an active living document.
Yes, yeah. In the guidance document and stuff, and that we make it clear and stuff like that. It's not all inclusive, and we'll be adding to it and stuff, and that as time goes by.
Okay, thank you so much.
Anything else?
Appreciate the forward thinking by you all. As technologies advance and chemicals can be used to make processes more efficient. Like, it's great to get upstream of just being clear and transparent with operators and having that accountability piece. As technologies are more integrated and more people are prospecting or continuing operations.
One of the things and stuff, we do get phone calls and have meetings and stuff. There's some supposedly green technologies for better milling and operations and stuff. So we want to be able to take a look at that. And over the course of 20 years and stuff, we've had some very odd ideas and stuff cross our desk and stuff about different ideas and stuff of how to extract different metals and stuff and that from and that. So we want to try to keep this as broad as possible so that we can encapsulate those so that we have a chance to start to have conversations. And hopefully, I would love nothing better than to see some really great green chemicals and stuff that would help be more environmentally friendly and that. But in the meantime and stuff that our conventional milling processes and extraction processes, they do use some chemicals and stuff in that we have to be mindful of.
Okay, Russ, thank you very much. That was very informative.
All right, thank you.
Are there any members of the public that wish to address the board with any comment? Do you know of any, Cammie?
Not as of today, not as of this moment.
There you go. Chuck, do we need to do anything about an executive session? I see none on the agenda.
Yeah, not this month. We may have updates on judicial review stuff the next month or two, but nothing that we need to go into executive session for today.
Okay, thanks. Thanks to the board, and I apologize for my erratic internet. Maybe some of the new Biden money will help rectify some of that. Hopefully, we need to stay in touch. But thank you so much for your patience, and thanks for the board today. I thought it was a very good meeting. And unless there's other subjects that the board or anyone wants to bring up, we'll stand adjourned.
All right, thanks everybody.
Thank you.
Take care, everyone.
Thanks, everyone.
Thanks.